In the previous 2 hours, we have made a general overview on EU policies on access to justice and the use of ADR systems. So we have talked about the EU intervention in promoting the improvement of ADR systems among the EU areas. We have stopped, in particular, after the analysis of the main provisions contained in the EU Mediation Directive of 2008. Today, and in these 2 hours, in the next 2 hours, I'd like to make some reflection on the Mediation Directive and to analyze the development from 2008 until today, analyzing also a decision of the ECJ and the new directive on ADR, which has come in 2030. So, first of all, my reflection on the Mediation Directive. The purpose of the Mediation Directive is to promote mediation as an alternative means of out-of-court settlement of disputes without devaluing litigation. So we are talking, of course, about a non-adjudicative method of dispute processes. Non-adjudicative means mainly based on negotiation between parties helped by the mediator, considered the third party. Overall, the directive seeks to ensure a balanced relationship between mediation and the judicial proceedings, and is intended to improve institutional judicial cooperation between member states among the EU areas, and from a point of view, from a citizen's point of view, so individual's point of view, it is about facilitating better access to justice. The scope of the aim of the application of the directive in a certain way is limited, and in particular I want to focus on 3 main aspects. First of all, the directive focuses on civil and commercial matters, and therefore it's mainly concerned with disputes in field of civil law, of private law, we could say, while administrative and criminal matters and areas are excluded, of course. Secondly, the directive has been taught for cross-border disputes only, even if, as we said, member states are free to are let it free by the EU to extend the scope of application of the internal national provisions also to domestic affairs. In this sense, the opinions of those member states who were skeptical on the first proposal of for a directive which also applied to domestic affairs were able to prevail. In fact, there are states